Well, hello there and welcome again to the Employment Law Show. So good to have you here for the next 30 minutes. I guarantee you'll learn a lot. Just stay tuned and feel free to contribute anytime. How do you do that? You can always reach out by email to Lior and his team. John Scholes here, Lior Samfiru there as well. help@employmentlawyer.ca. Phone call's always good, right? 1-855-821-5900. And the website built just for you to learn and reach out again and have access to what we call the severance calculator. pocketemploymentlawyer.ca. It's free, it's anonymous, and it was built just for you. So feel free to use that anytime you would like. Performance review for employees. That's going to be the main topic in just a bit. We'll get some phone calls from our radio shows across the country, some emails, and so much more. So let's get cooking. We always start, Lior, with the week that was. What do you got, pal?
Hey, John. Great to be here. Employment law is the topic of the day. Well, it's the topic on every show, but it's because it's a large topic. It's a topic that we all are affected by it. If you have a job, then guess what? Employment law is so relevant to you. It impacts so much of what you do. If you think about it, you're probably spending more time working than you're doing other things. More time than you're spending with your family, more time than you're spending doing your hobbies. That's why employment law is so important. It impacts probably the biggest thing, or the thing, at least the thing that we spend the most time doing. And so many people don't know what their rights are. They have questions, or when a problem arises, they may assume that there's no options, that the law is not really on their side. Well, I'm here to tell you that, yeah, the law is on your side. And if you know how the law operates and you understand your rights, you'll be better informed, better educated, and you're not going to be concerned when something bad happens, because you'll know. I know what to do. I know what to say. That is exactly what the show is all about. Now, I can only talk about so many topics on the show. So if you want to continue the discussion, or if you have a question that we haven't covered, or you want me to roll up my sleeves and get to work on your specific matter, easy to do. We'll give you contact information throughout the show. You can reach out to myself and my team across Canada, and we'll make sure that you're taken care of. But let's talk about the situation that came across my desk, and I'm actually cheating here. It's a situation that you told me about, but I found it to be so interesting that I think it's worth talking about on the show right now. So you told me about a friend of yours that works in a gym. Unfortunately, he was in a car accident. He was supposed to work the night shift that night, and he was pretty banged up and wasn't able to work his shift that night. Called his employer, the owner of the gym, said, I'm not going to be able to come in tonight. I'm in really rough shape, big car accident. Employer said, no, well, you have to. There's no one else. You better come in. Person says, I can't. Employer says, you have to. So employee says, okay, well, then I quit. Too bad. I'm not coming anymore. Goodbye. But the question became, of course, well, what happened here? Who was in the right? Who was in the wrong? Well, let's break this down here. First of all, his employer did not have the ability to insist that he come in. If he has a serious and a real legitimate medical issue, well, his employer has to figure out a way to accommodate that. Yes, part of being a business owner is you have to deal with those difficult situations where last minute you don't have an employee. It just comes with the territory. So you can't be penalized if you're sick and can't come into work. You can't be penalized because you have a medical condition. That's the employer's issue. There's no such thing as telling you, no, don't do what your doctor says, ignore your medical condition. Can't do that. So what your friend should have done, your friend should have said, well, sorry, can't do it. I'll be back when I can. Not resign. That was the mistake that your friend made. Right. Resigning here is not the right approach, because if you resign, you've walked away from your rights. There's nothing else owed to you. There was no need for that. Now, I understand your friend probably thought, well, I have no choice because my employer is telling me that I have to come in. Well, there is a choice, and the choice is, no, I am not coming in, and I'll see you when I'm cleared. By resigning, now your friend is not owed anything. So don't ever do that. So the lesson here is also this. Never resign unless you've decided you don't want to work there anymore. Never resign because you feel like this person did, that there's no other option. There's always another option. And that option is, no, I'm going to do what my doctor tells me, or I'm going to come into work when I'm able to. Don't resign unless you want to. That's just simply a way to walk away from your rights, and you don't want to do that.
You know, it's interesting in this case, and I guess every case, when there's an injury of this type, or you're sick or you're off work, we always talk about your doctor, your medical team is the gatekeeper of your health, and they have the final say when it comes to being able to work or not. In this particular case, it may have been, yeah, he was in a car accident that night. He was, black and blue. He wouldn't have a chance to get to his doctor maybe for a few days or a few weeks. Maybe that's why he panicked. I can't provide that note right now. Can he still say, when I get to my doctor, I will provide you that note and legitimize what I'm saying I can't work?
you have a reasonable period of time to get to your doctor. Everyone knows you can't just go to the doctor today if you're sick today or something happened today. It may take a few days and maybe even longer, depending on where you live and who your doctor is. So that's absolutely fine. That's why his employer should have allowed him to be off. And if at some point he couldn't corroborate his absence by getting something from a doctor at some point, well, then there may be an issue. But it's absolutely fine to say, I can't come into work for medical reasons. I will give you a doctor's note as soon as I can. And the employer, frankly, can't do anything about that.
And I didn't go as far as to tell him what his severance might have been, because I kind of know doing this show so long for you, but he'd only been there for a few months. I think he would have been shocked what you're going to tell us he could have possibly got from severance.
Yeah, so even after a few months of employment, that's a very good point, he's going to be owed a few months severance. It could be 3, it could be 4, it could be 6 months of severance, even after a few months. So it's not like he walked away from 1 week's pay. That severance is calculated in the months. Very important for you to remember as well. Even if you work for a company for a short period of time, 2 months, 6 months, a year, you're still owed substantial amount of severance. Severance that's calculated in months, not weeks. Don't believe me? Check out our severance calculator. Again, it's pocketemploymentlawyer.ca.
Lior is correct. That is one great way to reach out. You can always use the phone call as well, 1-855-821-5900. Help at employmentlawyer.ca is a way to do that too. But we have a radio show. We have several radio shows across the country for the last 10 years. We've been doing that. You always phone in. You have wonderful questions. We play them back on the show. We talk about them. Again, it's a learning opportunity. So the first phone call, Lior, for today's show from the radio show is coming up right now.
Calling on behalf of my father. He's 74 years old, and he's been working with this company for about 17 years. Last year, he was handed basically a termination letter and told to go home. They eventually got him to come back, but they gave him a lower position. He was put in just a warehouse. So earlier this year, he was given another letter, but this time giving him 6 months' notice.
Well, okay. I mean, there's a lot of things here to break down, and I could do a whole show just on this call, to be honest with you. Number one, that initial layoff was a termination. The company didn't have a right to put him on that temporary layoff, so he didn't even have to come back. He could have treated it as a termination and gotten his severance then. Now, when they brought him back, of course, that demotion, lower position, that's a constructive dismissal. That doesn't allow, a company's not allowed to do that. He could, again, treat that as a termination and get severance. Of course, there's the overarching issue. Are they picking on him because he's 74 years old? He's older, and is that why they're doing that? That could be age discrimination. So any way you slice it, this person is entitled to severance. And listen, after all these years and at the age of 74, that's going to be a substantial amount. So we know he's owed severance. Let's see how much severance. We're going to go, of course, as I said before, to pocketemploymentlawyer.ca. You see our severance calculator tool. We're going to use it right now, our severance calculator, and let's see how much severance he is owed. So 17 years been there, a long time, 74 years of age. It's going to be difficult for him to find another job. You can see on that screen that he's owed as much as 22 months of severance. 22 months. So what the company did here is not legal. That's why he has those severance entitlements. And, I mentioned our severance calculator. Important to also say, of course, it's free, it's anonymous, it's strictly there for your benefit. There's no strings attached to it. So always the first place you go to if you lost your job, if you think you've been constructively dismissed, if you're worried about losing your job, just go to pocketemploymentlawyer.ca.
Best thing about this call is you always mention the different factors that are used to calculate severance, and the overbearing one in this is, like you just mentioned, 74 years old. People think that's a lot of severance he's getting, but I have friends that are our age and they're in their 40s, early 50s. They're having trouble competing with 25-year-olds. Never mind a guy who's 74. There's no way this guy's going to get a job within 2 months. It's just not going to happen. Hence the inflated severance.
Hence the inflated severance. That's why one of the 3 biggest factors is your age, and the law assumes, right or wrong, and I think correctly, that the longer it's going to take you longer to find the job. The older you are, the more severance for those reasons. It's not fair to expect a 74-year-old to take as long as a 24-year-old. That's why we have these significant severance entitlements, which of course can be as much as 2 years.
That temporary layoff, the first time he was on there, we said it was a termination. We know that. Are you still seeing, COVID's still active, but we're kind of in the wake of it now. Are you still seeing people on layoffs from that time?
I actually am. I'm still getting calls from people saying, I've been on layoff since March or April of 2020.
Wow.
Okay, that's a long time. And when is enough enough? And I say, well, wait a second. It was enough in 2020. When you were put on that layoff, you could have said that's a termination of employment. You didn't have to wait. And now, 3 years later, almost now, no way is that legal. You can treat that as a termination. You can decide now, and frankly, you should decide now, I've had enough. I want my severance and I want to move on.
Another way to reach out, terminationquestions.com. Again, that's free for you to use anytime, terminationquestions.com. First one from it today is, after a recent storm, I was late coming into work. My employer advised me that my pay will be deducted if this happens again, and I'm in danger of losing my job for cause. I've never been late before, and I'm an efficient and productive employee. What can I do?
So let's start with it from the perspective of the employer first, and we'll talk about it from the perspective of the employee. An employer does have the right to expect that an employee show up to work on time.
Yep.
Even if it's bad weather, ultimately it is the employee's responsibility to account for that and to take their time and leave early to be at work on time, even again if it's bad weather. But the question is, what happens if despite that the employee is not on time? Maybe they didn't plan accordingly, maybe they didn't realize it was that bad, they didn't leave the house on time, so they're late. Can they just be punished for that? Well, no, not so fast. This employer is saying, well, we're going to let you go for cause if it happens again. Yeah, no, it's going to take more than that. You would need several incidents like that where the employee was warned in advance. Clearly they don't care. Clearly they're not getting it. Then and maybe only then can the company consider a termination for cause, and that's because it's very difficult to let someone go for cause. It's extremely difficult. It's reserved for the worst offenders, and being late is just not going to do it unless it's such a consistent thing and they've tried to correct the behavior and they failed. So I wouldn't be too worried about that situation. You're not going to be fired for cause because you missed work or you were late to work because of bad weather. You should be at work on time. I'm not saying otherwise. But the fact that maybe you didn't do what you were supposed to does not mean you can be fired for cause.
All right, guys, we'll take a short break. As mentioned, our main topic for today is performance reviews for employees. We'll get to that on the other side of the break. In the meantime, 1-855-821-5900 to reach out to Lior and his team. Help at employmentlawyer.ca as well. We're coming right back. Stick around. People think contractors aren't owed severance. Employmentlawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. Employmentlawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at employmentlawyer.ca. And welcome back. Thanks for hanging around. Employment Law Show every week. You can reach out anytime, not just once a week, to Lior, 1-855-821-5900. That is the number. Feel free to call with your own questions and concerns. Have a lengthier chat with one of Lior's team. You can also email help at employmentlawyer.ca. Okay, let's get into our main topic for today, Lior. Performance review primer for employees. Number one, an employee is within their right to critique and review an employee's performance and conduct. Yep.
Listen, we talked before the break about the fact that an employer can expect an employee to be on time, but an employer can expect a certain level of performance from their employees, and they're allowed to monitor that performance, and they're allowed to critique that performance and even engage in discipline when that's needed. So an employer that does that is not overstepping necessarily. An employer can certainly do that, and a good employer, in fact, stays on top of those things. Make sure that the employees are doing their job, make sure that policies are being followed, and of course deals with situations with the employees not doing what they're supposed to. A bad employer is the one that just ignores things and looks the other way. That's just an invitation for problems down the road. But it has to be legitimate. We're seeing, and I've certainly seen situations where an employer goes overboard and is too involved and is not doing it for good faith and is really trying to push employees to leave and trying to make the work situation uncomfortable to the point that it becomes bullying and harassment. That is not appropriate. You can't overstretch and you can't go overboard. If it's legitimate, done in good faith, fine. If it's in bad faith, if it crosses the line over into bullying and harassment, not legal at all, and there are absolutely legal repercussions for doing that.
Performance reviews. Point number 2 is this. If an employee does not agree with a performance review, they can and should voice their disagreement, but in writing.
Absolutely. And then, you've said exactly the key here. It has to be in writing. If your employer puts you on a performance review, a negative review, and you just put your head down because you're not happy and you continue working, it's the same thing as if you've just accepted. It's the same thing as if you had said, I agree, this is 100% correct, no problem, employer. The reason why you don't want to do that, because a negative performance review oftentimes is a step towards a termination for cause. What the company may be trying to do is build up a case and say, well, we gave him a bad performance review. It didn't improve the performance. He accepted it. Now we're just going to let him go for cause. We don't have to pay any severance. It is a way a company often tries to do that, to get to the point when they terminate you for cause. So how do you combat that? How do you avoid that situation altogether? Very simply, as John said, you respond. You don't just accept it. You say, I don't agree with this, or here's the information that's missing, or here's a different perspective, employer, that you need to have. Of course, you're not going to be rude about it. You're not going to be disrespectful. That's never a good idea. But if you do it professionally and respectfully, email works great. By doing that, you're protecting yourself. By doing that, you're not going to be considered to have accepted what your employer did, and you're going to make it that much more difficult for the company to terminate you for cause. So if it's not something that you agree with, say so. If it's 100% accurate, and if you agree with it completely, okay, do your best to move on. But if you don't agree with it, say so.
Number 3 may be a little bit of a shock for smaller employers that just aren't savvy when it comes to this stuff, and that is employers can't change an employee's pay, duties, or job title because of a bad performance review.
Exactly. So an employer may say, well, we don't think you're doing such a good job in position A, so we're just going to put you in position B, and guess what? Position B comes with a pay decrease or different hours, maybe a relocation. Can't do that. And by the way, they can't do that even if they're right that the performance is not great in the first job. Why? Because we still have laws dealing with constructive dismissal. And then if an employer makes a significant change to the terms of employment, such as a demotion, such as a big pay raise, you can treat that as a termination of employment. What the employer should be doing, if you're not doing a particularly good job in your original job, is work with you on improving it. Give you the tools that you need, give you the support that you need, or maybe discipline you if it's warranted. But they can't just say, well, we've taken it upon ourselves to change your job. So the job that you used to have is very different from the job that you have now. Anytime the company does that, even if it's for performance reasons, this concept of constructive dismissal should come to mind. That would allow you potentially to leave and get severance. But I want to leave you with this thought on this point. And that is, I don't want anyone to say, well, I know it's a constructive dismissal, so I'm packing up and leaving today. No one leaves, no one does that until you speak to me first, right? Because we need to do it right. We need to make sure that it is, in fact, a constructive dismissal. But if you have a constructive dismissal, those are the remedies and the options that are available to you.
Again, focusing on performance reviews, this particular show, guys, and this final point is where a lot of employers do trip up. I know that's for sure. And that is employers often incorrectly use that bad performance review to justify firing somebody for cause this time.
Yeah, so this is where we need to, again, address the idea of a termination for cause and the fact that it's extremely difficult to terminate employment for cause. It's not enough to show that your performance maybe wasn't at the level that they wanted you to, for it to be. It's not enough to show that maybe you made a mistake at work. To terminate you for cause, you would have had to do something so bad, so extreme, that it's just not possible to continue employing you. And John, in my experience, most of the time, we're not even talking anywhere near that. When the company terminates supposedly for cause, yeah, maybe the employee did something wrong, but it's not bad enough. And that's especially true if your issue here is a performance issue, because it's the company's responsibility and legal obligation to try to improve that performance. So the question always becomes, what support did you give the employee? Did you give them a warning? Did you give them a final warning? Did they know that they could lose their job? And if you did all those things and you built the case and there were several warnings and the performance legitimately wasn't good and it wasn't getting better, maybe then you can consider a termination for cause. But unfortunately, most employers don't want to work that hard and they don't build up their case. That's when we have wrongful dismissal. So if your performance is not great, your employer lets you go because of it, you want to call me right away.
And that number again, 1-855-821-5900, website employmentlawyer.ca. That is also where you go to find a radio show that carries our radio program. And from one of those programs, our phone call number 2 for the day is coming up right now.
I've been with the company for over 25 years. The owner sold. They've asked me to stick around. I've been working with them for almost 9 months now. From the beginning, they pressured me. They wanted me to sign an employment agreement. I just didn't think I really needed to. Not much has changed. The other day he says, well, we're going to give you a car, but we want you to sign an employment agreement to get the car.
Seeing that big flashing red light.
Well, yeah, in a previous show, we talked about employment law red flags, and one of the big ones with the flashing lights was your employer just wants you to sign a new employment agreement. That is bad news. It's always bad news. And it may sound tempting. Well, I want the company car, so I'm going to sign that employment agreement. Well, what happens when you find out that that employment agreement also is going to cost you at some point $100,000 in severance, and it's going to give the company the right to put you on a temporary layoff, and it's going to give the company the right to demote you and reduce your pay? All of a sudden, getting the company car doesn't seem as important, and that's what an employment agreement does. If your employer wants you to sign a new employment agreement, there's a reason for it. And it's not to make things better for you. If they want to make things better, they'll just do it. They don't need you to sign an employment agreement. They want you to sign an employment agreement because it's better for the employer. It's going to save the employer money. It's going to give them rights they don't otherwise have. So don't agree to that. If you've been asked to sign an employment agreement, be concerned. It is a big deal, okay? Give me a call or send me a copy. Let me read it. Let me tell you what it says. And let's understand what you've been asked to sign before you sign it, not after.
Pretty tempting, though. Car's pretty sweet. I mean, it's better than the Delgraph for $3 and a Casio. There's no temptation there at all, right?
No. It's still probably not worth it, though.
That's right. We'll take a short break, get to another phone call on the other side. In the meantime, the number 1-855-821-5900 and help@employmentlawyer.ca. More coming up. Stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Employment Law Show. Welcome back. Thanks for sticking around. After the show and anytime, you can reach out to 1-855-821-5900 and help@employmentlawyer.ca. Also, the website, pocketemploymentlawyer.ca, is there for you to learn so much about what we talk about on the show, even before that phone call, and you'll have access to the severance calculator as well. Phone call number 3 from one of our many radio shows is coming up right now. Let's get to it.
A little while back, I was working out at the plant. It was coming up to Christmas, and then layoffs were coming around. And then I got offered to go cover the co-ops as a foreman. And then last minute, they pulled the pin on that, and they said I wasn't qualified, and they gave the position to someone else. I got terminated.
And how long did you work there for?
6 months.
What did they pay you, or did they pay you anything by way of severance?
No, they didn't.
Well, why would an employer do that? You have an employee and you're going to dangle a carrot and they're getting excited, another position. Oh, no, that's not happening. Instead, you're gone. Not a nice thing to do. I think a good employer is not going to do that. But the question for this show is not whether this employer is nice. The question is whether or not what this employer did is legal. And the termination itself, unfair as it was, it is legal. Why? We know this by now, that an employer generally has the right to let an employee go pretty much for any reason, as long as severance is paid. So the act of letting this person go, even in these circumstances where he was promised something and never happened, and instead he was let go, even in these circumstances, the termination itself is not illegal. It is a legal termination, but severance has to be paid. This person said after 6 months, he didn't get any severance. And maybe that company thought, well, he only worked there for a few months. Why would we have to pay him something? Or maybe he worked in construction. We hear all the time that employers believe in construction, you don't pay severance. Wrong. You absolutely get severance in construction as well. So the question then becomes, well, okay, you've convinced us, Lior, he gets severance. Well, how much severance? Is it a week? Is it something else? let's go to pocketemploymentlawyer.ca one more time. Let's use our severance calculator tool, something that you can do at home yourself, and let's find out how much severance this person gets after 6 months when he got nothing. So he's a foreman, 6 months on the job. He got no severance, but you see there he gets anywhere from 3 to 6 months of severance. Not a week, not 2 weeks, not even 3, John. Instead, 3 to 6 months.
Yeah.
That's how much he gets. And by the way, short service employees, we know that, get treated disproportionately better when it comes to severance. Same with you at home. If you lost your job after 3 months, after 6 months, after 30 years, doesn't matter. Go to pocketemploymentlawyer.ca and use our severance calculator.
I want to mention as well, in addition to, of course, this TV show and radio show, Lior hosts live streams on YouTube and Facebook and LinkedIn. You want to join in and be there at ST Lawyers, to do that. And from the live stream, Lior goes like this. I worked for 4 years for my employer. Each year, I received a very substantial bonus until the year I took maternity leave. I was the only one of my colleagues who didn't get my bonus, and it appears I may not get it again next year. What should I do?
Well, obviously that's just wrong. And you know, we've talked about this before, that even in this day and age when employers should know better, we still are seeing, and I'm seeing, employers that are not treating employees properly coming back from maternity leave. You can't be mistreated or treated differently because you took a maternity leave or parental leave, whether you're a father or a mother. You cannot be treated differently. And if that means, well, we're not paying you a bonus because of that, or we're going to penalize you somehow, not only is that a human rights violation, it could be an Employment Standards Act violation. It can also be a constructive dismissal. It's not legal. So if you ever find yourself in a situation where something has happened because you took a parental leave, your job changed, your compensation changed, you didn't get an amount that's owing to you, you didn't get a pay raise that you expected. If anything like that happens, red flag, okay? Not legal. There are things you can do, and it starts by giving me a call.
1-855-821-5900, by the way, that number, anytime. Use it, reach out and talk to Lior and his team. We'll get to another email question here with our remaining minutes, pal. It's my company is looking to relocate the office from its current location. The move will result in over an hour added to my commute. I asked if a work-from-home position was possible, but was denied. Do I have to accept this relocation?
So, see that often, especially, by the way, coming out of the pandemic. Employers sometimes have decided to resize their offices. Maybe they didn't need as much space, or they decided to move somewhere. So very, very important that we understand what that means. This goes back to the idea that an employer doesn't have a right to make a significant change to the terms of employment. So if they moved across the street, that's not a significant change, right? If they move to a different province, obviously that's a massive change. Most situations are going to be somewhere in between, which is why that hour is kind of that guideline. If that change that the company is implementing, if that move is going to change your commute by more than an hour, or an hour or more, just like this person, we're in constructive dismissal territory. If it's less than an hour, probably not. So if the move is going to affect you by more than an hour, you then have a right. You can, or have an option, I should say. You can accept it and continue working, and you're commuting the extra hour, sure. Or you can treat that as a termination of employment and get your full severance. You can do that. You have that option. So it's not about the number of kilometers that the company has moved. It's about how it impacts you. And whether you have a car, and whether you're older or younger, all those are relevant factors that may cause this to be a constructive dismissal.
It's interesting you mentioned that. So if it's two people working the same place, they're supposed to go to a different place. One person drives, the other one has 3 buses, 2 subways, and a sled dog. I mean, that's going to be a completely different metric for them, right? They can say no.
That's right. And you know, I've had cases before where someone, their company is relocated. They didn't go very far. It was only, a few kilometers down. But because this person didn't drive, it would take them forever to get there with public transportation. That was a constructive dismissal. So the distance where the company is relocating can be small. But if it impacts you, maybe it's because of traffic flows, maybe because you don't have a car. If that's how it impacts you, absolutely constructive dismissal, John.
Can you take it out for a little spin and then decide? Yeah.
You can always do that.
Okay.
In writing, tell your employer, I'm going to try it and see how it impacts me, and then you can make the decision, but it has to be in writing. All
right, good stuff again for another week. Appreciate you contributing to the show with phone calls, emails, otherwise. You can always reach out to Lior now that we're done anytime. 1-855-821-5900. help@employmentlawyer.ca is that email address. And again, that website, oh so important. Keep it on your phone. Bookmark it, pocketemploymentlawyer.ca, and you'll have access free and anonymous to the severance calculator as well. And we'll catch you next time right here on the Employment Law Show.